So as a military member, you have the ability to say, listen, I refuse to do this Article 15 NJP and go to a summary court martial. At that point, would you take on clients to defend them in a summary court martial, or is that something you don't really represent?
It really depends. At its basic concept, you can turn down NJP. Now, when I tell clients, we get a lot of calls that people say, hey, I'm going to turn down this NJP. I'm typically in the business of getting people out of trial, not getting people into trial. And so I don't really recommend turning down an NJP unless you have a hell of a good reason to do so. And you have to have strong set of evidence and strong set of facts, because you're really elevating something from an NJP all the way to potentially a criminal trial. And now, while there are different levels, we talked about the levels earlier, right? You have in NJP, you have a summary court martial, then you have basically a special court martial. Then you have a special court martial, which can authorize a bad conduct discharge, and a general court martial. You would think that normally, if you turn down NJP, it would go from one level to the next. For example, I turn down NJP, it's going to go to a summary court martial. That's not always the case. I've got a Marine who turned down a NJP before we were brought on board, and the command got so pissed off about it. It's very Marine Corps-esque, right? They went straight to a general court martial. I mean, it's like do not pass go. They went straight to a general court martial. Now, 10 months later, the charges were withdrawn and dismissed because it was a bad set of facts that could never have been proven. But the command wanted to prove their point. It went straight to a GCM because they want to ensure other Marines see this and don't turn down NJPs, right? And most services don't do that. In the Navy, oftentimes, if you turn down captain's mast, oftentimes they won't even go to a court martial because they're too busy. Oftentimes, it will go directly to an ADSET or a discharge board, or other services, it can go to a summarized or a special court martial. So with that being said, each case is very, very unique, and you really need to speak with counsel before you make that decision to turn it down, because you can turn down a court martial, let's say it's a drug pop, and have a pissed off commander. Next thing you know, you're at a general court martial. But again, that's something that we can certainly advise on. And if there's a situation where the case does go to a court martial from an Article 15, yeah, then we can certainly take that on. We've done that many times in the past.